A new development in the Trayvon Martin case. The attorney for George Zimmerman, who's charged with second-degree murder in the shooting death of Martin, has filed paperwork to request a new trial judge. Mark O'Mara is asking for the circuit court judge to recuse herself because of a possible conflict of interest. This is where it gets a little complicated. O'Mara became Zimmerman's attorney after being recommended by Mark Najim, who CNN recently hired as a legal analyst. That's Mark Najim. You've seen him on our air. Now, he's an Orlando lawyer, and he's also the law partner of the Judge Recksiedler's husband. Their firm turned down the case when Zimmerman asked them to represent him. They referred him to Mark O'Mara, who filed the recusal motion today. He joins me now. Mark, thanks for being with us. Earlier this afternoon, you filed this motion to recuse the judge. Are you confident that your request is actually going to be granted?
Yes, I do. The way the rule is set up is that once the presentation is made by a verified motion, the court should grant it. She could have an inquiry if she wanted to. I don't think she will. I think she's going to go ahead and grant it and move the case on to another judge.
Were you surprised that she didn't recuse herself? I mean, she brought this up the other day. It certainly could, whether or not there's conflict of interest, someone could argue there's the appearance of a conflict of interest.
Exactly, and there is an opportunity for the judge to do that. However, also, and the rules provide that it's the attorneys who present the motion to the judge. If it's reasonably well-founded and sworn to, it'll be granted. So it could be by the judge initially, but us doing it through motion is just as well.
Also today, CNN, along with a number of other news organizations, petitioned the court to reverse an order sealing court records in Zimmerman's prosecution, an order that you requested last week. Why do you feel the records should be sealed?
Well, my initial concern is that I knew there was going to be information flowing into the court file that included witnesses' names, telephone numbers, addresses. I actually had some information about Trayvon Martin in there as well. And my concern is that with the publicity this case has gotten so far, and with the interest from all sorts of people, that there may be a concern for some safety to some of those people should addresses be given out.
Well, if personal information about witnesses or individuals attached to the case were redacted from the records and the records were released in that form, would that be acceptable to you? Or is this part of wanting to, because when I talked to you a couple of days ago, you said you wanted to kind of, dial down the pressure or the focus on this. Is that part of this?
Yes, it is. I mean, it's an overall philosophy of trying to keep the information flow concentrated within the court system. It's much better handled there. And again, if information like this, even a police report with names on it, gets out, then my concern is that they're going to be spoken to. They're going to be questioned. There's going to be 4 or 5 different statements from this one witness, let's say, and then we have to sift through all of that to try and get to what is the truth.
How often are you in communication now with George Zimmerman, and how is he doing?
Daily basis, at least a couple of times a day. And again, he's doing well physically. He wants out. He is certainly frightened as to what's going on. He's very concerned with the process, but I think he understands it.
You said he's frightened about what's going on?
Well, he's
I'm sorry, is that the word you used? Yeah.
Yes, frightened.
Okay. In terms of your actual meetings, are they face-to-face? Are they over the telephone?
Face-to-face and over the telephone. I saw him earlier this afternoon, spoke to him again on the phone. I try and get to see him at least every couple of days, particularly during the time that he's in. Hopefully he'll be out soon. Yeah,
you have a bond hearing coming up this Friday. What do you think the likelihood is that he could actually get out?
Well, our bond schedule says it's a no bond status until a judge reviews it. When the judge reviews it, he does or she does what we call an author inquiry. Basically, with a case where you're going to try and keep somebody in pre-trial, which I would consider pre-trial punishment because they've not been convicted of anything yet, then the court has to look at it and in a case like this decide that the proof is evident and the presumption great. Proof, of course, evidence. Evidence, look at Webster's, I guess, for a good definition of what evident is, but certainly would seem to be corroborated, unopposed, undeniable. And then the presumption of guilt has to be great. Our case law has interpreted that standard, the standard to apply in an author inquiry, to be greater than beyond a reasonable doubt. So if the judge follows the law, the judge would have to make a determination that the proof of guilt is evident. Well, I'm sorry, the proof is evident and the presumption is great. I'm hoping that the judge is not going to decide that and we'll get him out on Friday. Of course, maybe for the last day or two, I'm going to be able to argue ignorance because I haven't seen the discovery yet. I hope to see some of it before Friday so I can be properly prepared for the hearing and determine what the state is going to present and maybe rebut it.
And if he did get out, are you concerned about his safety?
Very concerned about his safety. The concern, of course, is once we get him out, and I believe he deserves to be out, and I need him out for our defense purposes, is we need to keep him safe. Again, there's been a lot of emotions that have come forward in this case, and some of those emotions are showing themselves in bad ways. And I'm just hopeful that we can get him out, keep him safe, and then give me the time to do my job.
Mark O'Mara, appreciate your time.